So, very first panel of the CPDP 2020, like welcome, like the first panel today, like at this Petite Hall. It's about the GDPR, and I know that we will be discussing GDPR this week. So our panel is more like a reality check, and before getting into the details of the panel is organized by Heinrich-Böll Foundation and the TCD, Transatlantic Consumer Dialogue, which is an umbrella organization for 80 plus consumer organizations from the both sides of the Atlantic, both Europe and the US, and I am the US chair of the Digital Policy Committee. And this is a joint project, and you can see some of the copies of the report there. Like this was a joint project of the Heinrich-Böll Foundation Europe and TCD. So we're going to discuss the research first, and then we have a very multi-stakeholder panel. Like we have the regulator, and we have the industry, and then I'm going to ask for their comments on the report, and then open the floor for the questions. So we want to have an interactive discussion. I don't know how many of you have read the report or have heard about the report. I know that Anna read the report. So, but it's a very interesting report, and I encourage you to have a look at it. We have some copies like in the front, but you can find more copies at the address stand out there at the hall. So, as I said, we have a multi-stakeholder panel here with the regulator, Heinrich-Böll Foundation, the industry, Microsoft, and Pat Walsh, civil society, and I am a civil society too. And we're going to talk about the report first. So, and I see people are coming. That's good. So we'll start with Pat because Pat was the principal researcher, and he was the author of this report. And I'll ask Pat to talk a little bit about the report and tell us about the research methodology and also the key findings. And then after that, I'm going to give the word to Zora. Zora was one of the mystery shoppers at the research, when we were conducting the research. She was the mystery shopper from Europe, and then I'll ask her to share her experiences, and she has lots of juicy stories when she was conducting this research, like she can tell us a little bit about those stories, and then I'll ask the regulator, Rudolph from CNIL, yeah. French Data Protection Agency. Only the insiders know, like, yeah. I mean, last year there were people visiting DC from CNIL, and like everyone was talking about these visitors from CNIL, and I was like, what is this CNIL? Is this a company? And everyone was like, no, that's the French Data Protection Agency. So CNIL, Rudolph from CNIL, and I'll ask him to comment on the research. You know, because we are curious to hear the regulators' like point of view, and I know that he read the report, so he can really say like, oh, you know, let us review the report and we will get back to you. He's here to get back to us. And then Jeff, although this report is not about Microsoft, but you represent the industry viewpoint here, and then I'm going to ask you like. Your take on the report, and I know that you also read the report. At least one industry representative read our report. So before I start, I just want to get to know the audience. So I'm going to ask you, how many of you use Amazon? Okay, it's. I mean, if we had been in the US, everyone would have raised their hands, but. How many of you use Netflix? Okay, how about Spotify? Great. Okay, so this discussion is very, very relevant to you. Like, you can really relate to this discussion. It's your turn.
Hi. Well, welcome everybody, and I think it's fantastic that so many of you have turned out at 8:45. I think you'll get gold stars on the way out today. I was very fortunate to be asked to assist with this research by the Transatlantic Consumer Dialogue and by Heinrich-Böll, who funded it. And it was a rapid assessment of 3 online services, which was obviously Amazon and Netflix and Spotify. And it was focused and limited in its scope because of the time that was allowed and the financial resources also. But I think it's also important to say that, whilst this research looked at GDPR and it looked at the Privacy Directive and it looked at the CCPA in the US, it's important just to reflect that actually many of the things that the report highlights on transparency, on consent, on legitimate interests, actually have been part of European data protection law for decades. For decades. And the e-privacy directive has been in place for a decade. So when we think about the findings in the report, we should also reflect on the fact that, the GDPR wasn't a revolution, it's an evolution. And so questions should be fundamentally asked of businesses that have been operating for many, many years at how these experiences can be as they are today when law has been in place for decades and decades. So the research looked at 2 US-based, so Amazon and Netflix, who offer services globally, but particularly here in the EU, and 1 EU-based, so Spotify, that operates services across the world and offers them into the US as well. We used mystery shoppers in the US and in Europe who set up accounts clean. I also took part in that research as Pat Walsh, being a customer of the entities, but also I set up synonymous identities using a genuine mobile phone number and a prepaid debit card because some of the services require you to either give a credit card number or something else. So that was quite interesting because I wanted to understand what the experiences were like from scratch also. We also use what the report refers to as access volunteers in the US and in Europe who submitted subject access requests, just standard subject access requests. I'd like a copy of my personal data, please. And also they looked at the process, how easy was that to find and exercise through company practices. And I also, as a researcher, submitted detailed requests, not only for copies of my personal data, but for supplemental information and for information where the privacy policies were lacking in terms of understanding why certain things were happening, and the responses have been quite illuminating, let's say, as someone. I've been doing this for 2 decades, and even I am genuinely surprised. So with the GDPR, of course, one of the things that we hear from industry is that, but it's a real burden because it's requiring us to give consumers more and more information, and that is true. Because the information that you are required, that organizations are required to give individuals stretches to about 4 or 5 pages. Simon, you can tell me if I'm incorrect, about 4 or 5 pages of information in the GDPR. And you have to provide it in simple, clear, intelligible ways, right? Easily accessible. And I think one of the things that we found is that the GDPR has led to more information being supplied to help people become and make informed decisions. And however, that hasn't necessarily translated into a change in business practice in terms of how you provide information. For example, if I look at Amazon, it has a layered privacy policy approach, right? But actually, that isn't very clear. You still have to search for key information and search for key rights. Netflix was probably the worst of the 3 in that you absolutely have to search for anything that you want to understand about rights. Spotify had a layered approach, but again, it wasn't easy to locate or find or understand key information on rights, key information on how to exercise rights at all. And in fact, each of these policies, I used a tool to understand the readability of those policies, because even the European Data Protection Board, in its guidance on transparency, refers to the fact that organizations could, for example, conduct readability tests to understand how effective their privacy policies are. It seems to me that none of these three companies have read that transparency guidance, because when I looked at the readability using a Flesch-Kincaid tool that's been used by people like Professor Laura Faith Crane in the US since 2009, and by many others, and it's considered a good test of the readability and comprehension of texts. They all score difficult to read. When I look at some of the key texts in these privacy notices in relation to personalization, profiling, advertising, they actually score very confusing to read. And don't you think that where a company is using information about what mood you might be in that day, when they're using information, deep insights into how you might be feeling that day, into how to trigger you to take an action, to buy something, or to listen to something else, or to watch something else, don't you think that those sections that use such intimate level of detail in such vast quantities should actually not be very confusing to read, but actually should be very easy to read and very easy to understand? So we find things like that. And then on each of the websites, the other things that we found is you are absolutely tracked. From the moment you visit those websites, you are tracked. You are tracked for their own advertising and profiling, personalization, but you are tracked in relation to the third-party advertising relationships that they have. Now, where those companies offer services to people in the EU, they were presented with cookie notices. And oh my goodness me, to say that we have had e-privacy law for a decade, glances over to a regulator, then I think actually we should be asking very serious questions as to why, particularly after the Planet 49 case in the Court of Justice of the EU, why we have major organizations like this that still say things like, by using this website, you consent. Absolutely not. Those days are gone. Those days should never have existed in the first place. So I'd be curious to hear what a regulator and a big corporation has to say about such practices. When it comes to those same companies offering services to people in the US, do you think a notice was given about pervasive tracking of individuals? No. I'm still searching for it. No, they didn't, but they did conduct a similar amount, in my view, of aggressive online tracking. When we looked at the Android apps, so we looked at Android apps because it's difficult to analyze iOS apps. Android apps, so for Spotify and Amazon, have trackers embedded for advertising purposes. We also found, what other things did we find? Defaults. Whoa. So have you all heard about dark patterns? If you haven't, look at the Norwegian Consumer Council. They've got a good report on dark patterns. Have a look, darkpatterns.org also. Henry Brignall done some good stuff on dark patterns there. So we found dark patterns in place. So how many of you use Spotify? Hands up. How many use Spotify from your desktop? How many use it just from your mobile? Fair balance. How many of you use it just from your mobile have ever visited your Spotify desktop account? 2 of you. I might suggest that you do visit your account from a desktop or from a laptop or from a tablet. So from a web browser, however you wish to do it. Because one of the dark patterns, excuse me, I've had a cough for 3 weeks and nearly lost my voice the other day, so I'm glad it's back. So if you have a Spotify...
Just before you get into the details, let's talk about the research. And I'd like to ask Zora, because she was one of the mystery shoppers in Europe, and she took part in this research. And she has some experiences that I think it would be interesting for the audience to hear, and then we can talk about the findings. But let's talk about the research. Okay. Zora, yeah, you were the researcher, the mystery shopper in Brussels. But maybe for the audience, like, just tell us what was the mystery? What did the mystery shoppers do, and how are your experiences, like, when you were conducting this research? What did you realize? Because we work with 5 mystery shoppers, like, no, 4, sorry. 1 in California, 1 in Washington, D.C., 1 in London, and 1 in Brussels. And like, when I talked to them, like, they all had different experiences, but they told us, like, all of them told us that, like, oh, we didn't really realize, like, how much data has been collected and, like, all the trackers. So, Zora.
Yes. So the mystery shopping, what does it what is it? Pat already tried to explain a little bit. So what we did was create pseudonymous identities and then create new accounts for the 3 services concerned. And then with these new identities, we went through everything, the terms of use, the privacy settings, the cookie settings. We read all that and we timed ourselves. We took note of how difficult we find it to read. Is it difficult to understand? Can we understand it? And one of the findings I had was, for example, in the Amazon privacy settings, it said these privacy settings are due to change, so you might want to come back from time to time to check this. But can you really expect this from the customers if it takes half an hour to read the privacy settings? I don't think so. And then what we also did was going through all the default settings, and I don't know if you realize this, but for example on Spotify, it is preset that your playlist and whatever you like on Spotify is shared with Facebook, for example. And on Amazon, there are 84 pre-ticked boxes of things that you might be interested in and that you will get commercial emails from. So that was quite shocking as well, because this is not how I understand privacy by default. And on Netflix, for example, one thing was that if you create a new account, you are automatically in their test program. So it's very short, it's very brief what they say about this test thing. It's just telling you, you will get content that first, before other users will see it. So you think like, oh yeah, I want to see things earlier than everybody else. Maybe I can get the best episodes of the series that I'm interested earlier. Of course I want to do that, but we don't really know what these tests are because there's no explanation of that. So this was the mystery shopping part, and there was also the access request. Do you want to get
before the access request? So I'm going to ask Pat, because Pat evaluated all the results from the mystery shoppers from California, Washington, D.C., London, and Berlin. How different they were? They were all same, or they were all same?
So Amazon US, absolutely, there was no right of access at all. In fact, Amazon US compared to Amazon EU, for the US customers, it was less transparent. It missed out key bits on purposes of processing, for example, and it had no right of access. And in fact, some of the mystery shoppers, when I looked at their experience, it was really shocking. Because at one point, for one of the mystery shoppers, they wanted access to her contacts, to their contacts, in order that they could verify the identity of some of those contacts to make sure they weren't on some particular list. It was really quite shocking. In relation to EU customers, it was really a mixed bag. I don't think any were that easy to exercise per se. Amazon, Netflix, for example, want you to provide proof of government-issued identity. yet they don't demand proof of government identity in order to open an account. So on my pseudonymous identity, which was in a name, an email address that existed, a mobile phone number that existed, and a debit card number that existed, I was unable to obtain my data because they wanted government-issued identity. I didn't actually have a government-issued identity for that identity. And on my own identity, me as Pat Walsh, I had to send some redacted proof of identity. So that's a matter that needs addressing because it's denying people's rights. And also, why should someone have to provide government-issued identity for this? And for me, that infringes on the GDPR, not just in relation to the article, but recital 57 also, which talks about different methodology for authenticating a person. I think then in terms of Amazon wasn't that easy. You were sent around in circles in terms of how to identify your right. I think, Burcu, I think you had similar experiences. Zora, you had similar experiences. Spotify is a little bit easier, and you can access it and make the request through your account. But just like Facebook, on their download tool, it doesn't include all the information that the company holds about you. In fact, you'll find that reflected in the report. And Spotify admitted to me that they hadn't given me all the data. And I'm still convinced that I don't have all the data. And same with Amazon, and same with Netflix. None of the profile data was supplied, none of the data that's held in relation and processed. And remember, this isn't about data that you hold. The right of access under the GDPR is about data undergoing processing. So what we found is that these companies try to navigate you, steer you towards data that's held in your account. So a process that's easy for them, not so great for you in terms of the data that you're entitled to receive, should you wish to receive it, of course.
Yeah, I mean, talking about access requests, so we had like 12 people, like 12 of our members. They filed access requests both in the US and the EU, and I was one of them. Like, I filed access requests and for Spotify and Amazon, and this research took place in November, September, October, and November. So it was before the CCPA. So the practices were different, and it was very interesting because when we request our data from Amazon, the answer was like, no, you don't have access to that data. Like, you live in the US and you don't have that right. But now that after the CCPA, things have changed. Now, like, the US consumers, like, we have access, and I made a request for my data from Amazon. I haven't heard back. Maybe they will tell me like, oh, sorry, you live in DC, and that feature is not available where you live. But the access requests were very interesting, and I know that Zora was like very surprised when she received her data from Netflix, right?
Yes, so in Europe it's a little bit easier. You just email the respective email address of the service. First of all, you have to find where you can access your data, which is not super easy. So you log on, you don't find it, and then at some point you use a popular search engine to find out how you can actually access your data. And they message you and tell you, well, you can already see your data. Just go to your profile. There's everything you ever gave to us, which is not true. So you still email them. You ask them, please give me a copy of all the data that you have. And in the EU, within 30 days, they have to respond. And they did. And I just bought a printed copy of my Netflix data to show to you. So it's 445 pages of my viewing history, my billing history, everything I ever liked, everything I ever rated. And it's quite revealing because, you know, it shows you when you watched what, for how long, with what device, did you stop it, what is your IP address, if your device changed. So it paints a pretty accurate picture of your personality, and from the customer point of view, we are super transparent towards the company, but we don't know so much about the company practices because, like Pat said, the data undergoing processing is not so clear for me from this pile of paper because I don't know why Netflix recommends certain things to me and not others. That isn't obvious from this a big pile of paper.
Okay, so now I'm going to ask the regulator and the industry, but before that, just to summarize the key findings of our research, so that you guys can comment. Users cannot avoid being tracked. Third parties track users. Privacy policies and other related policies are generally hard to read. Companies fail to provide proper transparency. Dark patterns appear to be present, and Amazon treats US users differently in terms of right to access. So, the regulators, like you are sitting next to me, so I'm going to ask you, you read the report. I just reminded you the key findings, and now it's your turn. What's your take?
Do you expect me to impose a fine to this to this company right now because I don't have such power?
Maybe we have like representatives from like Amazon, Spotify, or Netflix in the room, or their lawyers. Like, if you are here, please raise your hand because we want you to engage with this conversation. We send the letters and we try to get someone from these companies on the panel. But we weren't able to, but it will be interesting to hear from you guys. If you are in the room, please let us know. Okay, the regulator.
Yeah, good morning everyone. So I'm Rodolphe from the French DPA. I'm working at the Sanction and Litigation Department at the French authority. Well, first, the report is fantastic. I have to say it's very detailed, very accurate. And it shows, of course, that improvements are needed in many categories. So you might think, okay, what the Data Protection Authority are doing, what are they waiting to issue a fine or another corrective measure, because it appears to be clear infringement of the GDPR in this report. It's true that we, and I say we in the sense that all the DPA take together, we have yet to issue a big fine or corrective measure on an emblematic actor for a cross-border case. But I will come back to that later, but it takes a lot of time and resources. Well, from the CNIL perspective, I just have to remind you that we issued a fine last year against Google on this question in particular, and we focused on the validity of the consent and the lack of transparency when it comes to Google's privacy policy. So we imposed a fine of 50 million euros on Google for these two infringements. So I can just encourage you to read this wonderful decision. So even if it was not a cross-border case, it shows that DPAs are not shy to apply the text. And to be honest, I'm not worried about the future because I know that the Data Protection Authority are taking these issues very seriously and are right now working on it. It might take a bit longer than expected to see fines because when the text came into force in May 2018, well, a lot of people expected maybe that, okay, 1 year later in 2019, we will see big fines again, Google, Amazon, and all these big companies. But it might take a bit longer. Why? Well, because as you can imagine, the number of cases and complaints exploded in each of the DPA, and there is a huge invisible part of work made by the DPA. And for instance, in France, we received 13,000 complaints for the year 2019. And many of these complaints are solved just by exchanging with the data controller and are solved thanks to the intervention of the CNIL. But we don't publish every decision. We don't make a public statement about that. So I can assure you that there is a dialogue between the different authorities. We exchange a lot. but it takes time, you know, and in a lot of situations, a lot of cases that, for instance, the French authority is the lead authority. Well, in a cross-border case, we will ask our colleagues from other DPA, well, what do you think about this infringement? What do you think about the behavior of this company? And we have to reach a consensus before taking any action. And it really takes time. So I would like to say that be patient, it will come. You can reinvite me already for next year, and I hope next year I will have big cases, big cross-border cases to talk about. Yeah, so.
Okay, I'm going to ask Jeff now. And Jeff leads the privacy legal team at Microsoft, and he traveled all the way from Seattle here. So, Jeff, what's your take on this issue? And report and all the dark patterns, third-party trackers?
Sure, and the report's very interesting, and it's actually helpful to see what an independent researcher is going to find when they do the mystery shopping. I should say that we at Microsoft do mystery shopping ourselves, and we see whether we can actually support the kinds of lows that we're getting. One thing that Pat mentioned is that these rules have been in place for many years under the 95 directive, so why don't companies just do it right? And one of the things that I've seen, and I started working in privacy at Microsoft in 2007, and it was a sort of a niche area, and most of our customers didn't think a lot about where their data was going. The numbers are so much larger now, and it gets to an issue of privacy by design. How do you build a system that allows for these kind of data subject rights to be exercised at scale? We publish the numbers of people who are accessing their data through our systems, and they're very large. And very interesting thing is that they're even larger in the US than in Europe, and I think that's interesting in that it's not just a matter of what the law says, it's what people are interested in. And so we've had to do a bunch of work internally to make our systems support the kinds of, the numbers of requests that we're getting. So that's one thing that comes to mind as I look at this. I see what other companies are doing, what the report shows from some of our other colleagues in industry. Some other things in the report that were interesting, and some things that I'll actually object a bit to. The first is privacy statements. How easy is it to read a privacy statement? There's a continuing challenge, and has been for years, between having a short, understandable privacy statement and a longer privacy statement that covers all of the issues that happens with data, and that covers, frankly, all of the technical requirements of laws, including the GDPR, but also now CCPA, as far as listing out legal bases, listing out your data protection officer, now with CCPA providing specific language for your California residents, and in our case, we're extending that not just to Californian residents. So those are balances that we have to do every time we update our privacy statement. And it's actually, I find it harder for us because we have so many products. So we have to figure out how, when you're, say, an Xbox user, you can get quickly to the Xbox information and you don't get distracted by the information for whatever other product is out there. So it's a challenge. I'm not trying to get sympathy. I'm just saying that's what came to mind when I read the information about privacy statements. The other big issue I saw in the report was advertising cookies. And again, this is an issue that has been around for a while, but it's getting so much bigger as the advertising ecosystem grows. And it's an area where I think industry needs to have help from the regulators, and we're getting it. We're getting it, actually, it's interesting. The CNIL just published yesterday, I believe, English translation of their guidance, practical guidance on cookies. That follows guidance, I believe, from the UK ICO, the German DSK, the Spanish Data Protection Authority. Maybe I'm missing some. I know that the Irish is working on it. And there are actually some differences. And so when you're in industry and you're looking at this, you're like, some of the guidance that came out in the past has been superseded now by new guidance. The guidance is gelling. We all read the Planet 49 case when it came out, the judgment came out from the European Court of Justice. We all, I have to say, we all agree that pre-checked or pre-ticked checkboxes are not a way of getting consent. But then the question is, then what is? And so we're still working through that, and I think industry is working through that because the ecosystem is such a large one, and so many parties want to get consent to do this kind of online advertising. It's a challenge. I'm not going to make the challenge any smaller or say that there shouldn't be a challenge, but we're dealing with a cookie infrastructure that technically dates back, I believe, to the 90s, and trying to deal with it in today's world. It's an interesting, difficult one, and I'm hopeful that we can, in the next couple of years, get to a solution that works for everybody. Pat's right. It's a very European issue at the moment. In the US, we still offer people the ability not to be tracked for online advertising, but we do it in a different way. Well, there are ad blockers, and I'll say that browser manufacturers, including Microsoft, I'll plug for Microsoft Edge, we're working on improving those technologies for browser technology to let people make these choices in one place rather than have to deal with every site having a different setup. And that's a big problem, is every site seems to be putting together a different way. Even if they're using a similar consent framework, they have their own language on top of it. So trying to simplify things for users is a big issue. So I think those are the main things that I took away from the report, but if you have any other questions, I can refer.
Yeah, I'm going to ask another question to Pat, and then I'll follow up with you. So Pat, there you have this very interesting chart in the report. It's about the privacy notices and the cookie policies, and your finding is that it takes between 17 to 21 minutes to read these policies. Can you tell us a little bit about this? Because we've been talking about the cookie policies, all these privacy notices and everything, so I think it will be interesting for people to hear,
Yeah, okay, so a couple of things for me, but I'd just like to address one thing that Jeff said, that it's not just about cookies. There's a lot of third-party tracking that takes place that's not cookies, and ad blockers can only do so much, to be honest. And even when I looked at that chart, also you'll find that a number of these websites, apart from Amazon, used Facebook pixels. Now I have a little tool that shows them. Most people don't have such tools to show them what's happening. And as for cookies and consent, I've yet to find consent in practice, so, And just because you can doesn't mean to say that you should. In relation to the readability of privacy policies, I noticed that one of the companies has updated their policy. I got an email about 4 days ago that told me the policy had been updated on the 1st of January. So I looked at the policy again at 6 o'clock this morning, because that's the only chance I've had following the email just a few days ago from the change that took place 3 weeks ago. And I noticed the policy is 100 words less. And I noticed that it still grades the same, that it's still difficult, it still scores the same. But I noticed something unique, and maybe a regulator and maybe a business person can comment on this. So in this one company, it talks about, it had lumped together. It used to set out our legal basis, right? To provide personalized and improve your experience with blah and other services and products provided by blah. For example, by providing customized, personalized, or localized content, recommendations, features, and advertising on or outside of the Spotify service, including for third-party products and services. That's why my hair's this color. I have to read this stuff, right? So this, the legal basis apparently, was for the performance of a contract or for legitimate interests. So, when I ask these companies, and I have asked each of them, where's your LIA, your legitimate interest assessment? Pardon? You're not entitled to it. I'd like to object. You can't, apart from the personalized. I can't object to the personalization for this. I can only object to this legitimate interest for other purposes. In the change to the privacy policy from the 1st of January, they've kind of split some of this stuff out. But to personalize the service and for some of the other things, they've now added consent. So they've changed the privacy policy and they've inserted consent. That's good. So how on earth did they obtain this consent? Because when I go to log into this service, I'm presented with a cookie banner. that says by using this service, you agree, right? Now, the other day, when I was logged into my service, and then I visited one of their ad entities, I just visited the website, the ad entity website, which is a separate business of this company, recognized my username, and I can't disassociate them. And it operates across different browsers and across all of my devices, So I tweeted, and some of you that follow me on Twitter will probably know which company it is then, so I tweeted, have you also had this experience? Yes, they have. So where is this in the privacy policy? Because I can't see this stuff in this privacy policy. So I'm sorry, but to revise a privacy policy by reducing it by 100 words, not to make it any more intelligible, and to confuse things even more, well, you know what? Perhaps they ought to be doing mystery shopping in a different way.
Okay, here is my follow-up question to Jeff. How long is Microsoft's privacy policy, and is it different is it different in the US or the EU? Because we know that Microsoft decided to implement CCPA for everyone in the US-wide. So do you differentiate between the US and the EU, and do you know how long it is? And who drafts those privacy notices? You can say pass if you don't.
No, so we have one privacy statement for the world, we translate it. There are some things like in, the California requirements, we have a link off to that. There are some special things in Korea, for instance, that we have to do. But the core is the same. I can't tell you how long it is. I actually don't print it out, and it is a modular statement, but I'm not going to say it's short. And I will say that it's intended for several different audiences. It's intended, in some sense, for regulators to read the whole thing, and that's the lowest level of the layers, and we use a layered approach. There's a tremendous amount of detail. If you want to know all of the diagnostic data we collect from, for instance, Windows, you can get that there. But for the users who are trying to make a decision quickly and don't have the number of hours, I forget the number of hours, there's a higher level layer. And then we also look to have better information in the product. The way that we develop these privacy statements is we have to have the engineers provide us the actual facts. And so we have a system it's not really a system, it's a process, to pull from all of our various products any changes that they've made in the last however long, so that we can include that in, if it's necessary, in our privacy statement. What that generally means is that our privacy statement normally gets longer because we get new features. Sometimes we do get rid of old features, but people are still using those products usually, so there's a general tendency for the privacy statement to get longer, and then it requires us to go through and try to simplify it and find commonalities among the various features to try to simplify and shorten. And that's an ongoing process. It's managed out of the Privacy and Regulatory Affairs team on which I work. We have on that team, I report to Julie Brill, some of you may know, and she has a number of non-lawyers who try to make this statement look easy to read, and then, of course, I have to go in, and my team actually has to go in and make sure that we've met all of the legal requirements.
Okay, so let's take a few questions from the floor, if there are any questions. Yes, please. Can you microphone?
Thank you. I was wondering to the...
Can you introduce yourself?
Heinrich-Böll-Stiftung from the Norwegian Skatteetaten. It's a question to the French regulator. In a cross-border case, what do you do when you impose a fine on a transnational company with regard to the distribution of the fine? I mean, if it involves several countries, is the lead regulator the one that gets all the income from the fine, and none of the others? And the second question is, what do you do in terms of agreeing on a level which is reasonable as well? So that, I mean, obviously you have to have a punitive purpose back a fine, but I just wanted to know what you do so that you don't, to avoid litigation after you're imposing a fine.
To answer your first question, no, we don't share the cake. And basically the amount of the fine is recovered by the lead authority who imposed it. Of course, it means that probably some country will recover less money, and probably Ireland might recover a lot of money. And I'm not sure that I understood your second question. You were talking about how to avoid litigation.
More as how do you do the national authorities talk to one another to agree on more or less what's a reasonable level to fines for the fines?
Okay, so how do we agree?
Not in that case, but do you talk with one another to come to I mean, within the margin you have to impose a fine on a company? Do you more or less agree on what kind of infringement would entail? For example, €1 million, 3 million.
Proportionality.
Yeah.
Proportionality of the fine.
Yeah, exactly.
Okay, proportionality of the fine.
Yeah, if countries talk, if authorities from the different countries agree on certain levels.
There is already existing guidelines on because in the GDPR we have Article 83. We provide for the criteria to take into consideration whenever authority want to impose a fine. And within the EDPB, there is an existing working group whose mission is to draft guidelines on how to harmonize, and of course they can some differences can exist right now concerning the amount of fines, but it's a long-term issue. It's a long-term issue. And we are really talking on a regular basis about how to calculate this amount and try to keep a consistency. But it's very difficult so far because we don't have so many cases, and all cases are very, very different because we have a huge variety of infringement, of gravity of infringement. We have to deal with very, very small companies, very huge companies, so it's challenging, but we are working on it right now, and we plan to issue guidelines on these topics probably in 2021, hopefully.
We have another question there, lady in red.
Hi, I'm Guro, working for Telenor, Norwegian telco operator. And I have a question, sorry, to the regulator again. How quickly can we expect a common European guideline for the cookies? Because last 2 weeks ago, I was informed that the Belgian DPA had posed a fine to some smaller company here in Belgium because they didn't like their cookie solution. And they were very specific on how this cookie consent solution should be. And I experienced that we see a lot of different guidance, and it's super difficult for me as a privacy advisor in a big company to feel safe when I guide my people.
Thank you for your very easy question. First concerning the guidance, cookies are regulated by e-privacy, these all directives. So each country is supposed to apply its own national law, And that's why you can see some differences into the interpretation. Recently, the Spanish Protection Authority released guidelines saying that, well, whenever you go to website, if you continue to scroll and you navigate to this website, it means that you give your consent to cookies. That's not the position of the French Data Protection Authority. But the thing is, there is no, because it's 28 national law, you don't have this like obligation to reach consistency. Of course, we talk with each other, but I don't have any a date in mind when the EDPB or such European body will release guidelines on cookie. And what was you had 2 questions, sorry? Did I answer
it was
both?
actually this, and I was pointing also to the fine posed by Belgium.
Yeah.
Because it was very specific, and it's difficult for us to relate. We relate to our national regulator for e-com services, but they point again now to the data protection authorities in Norway, and the data protection authorities, they are quite strict, but they didn't say anything official. So when we get the information about fines being posted to a close neighbor as Belgium, we get very nervous. Though we are strict in our own policy, but it's kind of annoying that we cannot agree.
Foresee, yeah. Well, I understand. I would say that it depends of every national data protection, let's say, philosophy, because some have a very clear view on what companies could do and could not do with cookies. Some are still wondering what is a good line. And personally, in France, we haven't issued a fine on cookies for a long time now, because we're in the middle of the process of asking their opinion on civil society and companies, because we know that this regulation will have an impact on a lot of online services, and some websites will basically live thanks to the cookies. So of course it takes, in some country like France, I think there is an ongoing dialogue with these actors, and some other data protection authority. Well, I think in Belgium it's not the data protection authority who have competent for imposing fine. It's the, thank you Romain for presiding. So.
Can we pass the microphone to the lady in red there? Yeah.
Hello, good morning. I'm Gloria González-Fuster from VUB in Brussels, and thank you for this great panel. I have 2 short questions, one for Pat. I'm not a Spotify user, but you were starting to say something interesting about Spotify and dark patterns about the desktop, and I think you were interrupted. So if you could just explain what was about the desktop and the mobile users. And the second question is for the industry representative. I think it's Microsoft, and I like the comment about the fact that privacy policies are difficult to write when you're addressing different audiences, and you have to address in the same text people from Korea, from California, from the regulators, everybody. So is there anything concretely that prevents you from having a number of different privacy policies, that instead of a Russian doll, you have just, you know that I'm not in Korea, so I don't have to read the part about Korea, I don't have to read about California. Can we just have 1, 2, 3, 10, 100 different privacy policies? Thank you.
Okay, yeah. Just before I answer Gloria's question on the Spotify thing, in relation to cookie guidance, the UDPB, look, as a business, ethically, you've got to make a decision. This law's been in place for a decade, right, that says that you need consent for purposes not strictly necessary. You want to track people and profile them for advertising purposes, get their consent. It's very clear what consent is, and the court has ruled on what consent is. So but I agree, regulators need to come together. One regulator, the Spanish regulator, has issued cookie guidance in association with ad industry trade groups. That's a bit like asking Dracula to write the National Blood Bank policy, right? Come on. And then in relation to Gloria and Spotify, if you have the Spotify desktop app, then there are two things. So the desktop app, and then there is the accessing your account via a browser on the desktop app. If you go into, and it's in the report, if you go into show advanced settings, go to your profile settings, show advanced settings, right at the bottom, you will find something. You will find a default called privacy. That's not privacy in my book, and I've been doing this for 2 decades. It looks like it's off, but actually, because it looks like it's off, it's actually on. You actually have to turn it, slide the button so it becomes green in order to turn off that privacy setting, which is all about cookie tracking. It's also linked to advertising. If you go to your account and via a web browser and go to profile, go to account overview, on the left-hand side, you'll see a range of options. One is called apps. If you click in apps, you will probably see a Spotify advertising cookie that is set. Right? So if you look at the revised policy, that's consent, right? When did you ever consent? These are dark patterns. And if you go to turn off, for example, in the desktop app, that default, you get a message that nudges you, oh, geez, if I turn this on, which is turning off the tracking, then it says your experience might not be as good as it could be and things might not work properly. Oh, I better not turn it off then. I mean, come on, this is a dark pattern in my view. So that was it, Gloria. Just check those things. And then, by the way, if you are going to go to then visit in the same browser, or, you know, Ad Studio, which is one of their things, then that will recognize, and that will also respawn, not just that cookie, but it will spawn, it's like the son of the devil, isn't it? It will spawn another cookie that's related to the Ad Studio tracking and cookie. And I've spent numerous hours in the past week alone just trying to stop this stuff happening, and it isn't happening, and I will blog very shortly about some of these experiences. I mean, if you look at, Spotify has a couple of ad businesses also that are related to all of this. So, you know, you are what you stream. We know our fans, like, really know them. The more they stream, the more we learn. Billions of data points collected daily. Netflix, how many of you are aware that Netflix has a research arm as well, separate entity? And Zora talked about a little setting. What was it again, Zora, that you had that setting?
The test user.
The test user. It's on by default, right? So they have a research lab. Go and have a look at the Netflix research lab. Have a look at the different things that they're researching. It's all about you, of course.
Good question about audiences, and I think of 2 different kinds of audience differences. One is audiences of consumers versus audiences of regulators reading a privacy statement, and we want to make sure that it works for both. The issue about audiences being different in different geographies is one where I don't want to make too much of it. Didn't want to say that we have only one privacy statement for the whole world, because we have these variances. But if you're in Europe, we hope that you don't get confused. We don't put anything about the Korean requirements there. Another example is we don't have information about the US law about children's privacy, because GDPR handles that differently. We want to make sure people see the right things. Similarly, we wouldn't want there's some special language actually that we put into our French version because of the CNIL's looking at our statement a couple of years ago. Again, that wouldn't show up for other countries. So I didn't want to say we have one privacy statement across the world, but largely, I don't know what the percentage is, but it's certainly in the 90s. It's the same.
Okay, more questions. And there is a question there. And then we can have there is one in the back and in the front.
Kasper Drążewski, I work for BEUC, the European Consumer Organization. My question is to Pat. First of all, congratulations. Thank you for your work. It's very important. You said something that resonates very strongly with what we learned from the Norwegian Out of Control report, which launched last week. it makes points about data being transferred from companies which rely on consent to companies which only rely on legitimate interest. You see where I'm going with this. You mentioned legitimate interest assessments. In your experience, how often are these actually made, and what form do they take?
I don't think that they. I don't think that they are made. I've asked a number of organisations for legitimate interest assessment. I'm told I'm not entitled to them at all. And I think this is something that we need all EU regulators to determine. Legitimate interest was under the old directive as well, by the way. It wasn't introduced by the GDPR. So again, it's nothing new. But what I do see in my experience is an abuse of legitimate interest as a way of avoiding consent when consent is should be the most appropriate. But it's like yesterday, I saw that I was presented with an online cookie notice that asked me to consent, and I didn't. So I got another dialog box that said, okay, I do not consent to any of these partners. Fair enough, I thought. But then in the text, a little bit of text underneath it says, consent is not always required, which means you may already be opted in to some partners and their data users via legitimate interests. When have you ever been asked, in your experience, to opt into legitimate interests? It's one of the sneakiest conditions that companies are abusing and using at the moment. It's normally mentioned in the shadows of a privacy policy. It is not elevated into the light of the user experience at all by any of these major companies that I have seen. Nor, for example, in this research, have I found that these companies elevate, for example, your very clear right to object to legitimate interests and a mechanism, an easy-to-use mechanism to object to legitimate interests. I've also found, for example, not just legitimate interests, but I have some of these companies telling me, we don't do automatic decision-making, all that profiling and targeting of you on very intimate data that we've kept forever. And by the way, on data retention, these companies are keeping your data forever, it seems. We don't do automated decision-making as defined in the GDPR. I also believe in Santa Claus, by the way.
Okay, I'll ask Jeff, what is legitimate interest for Microsoft?
We actually do a bunch of legitimate interest balancing. It's something that for our DPIAs, data protection impact assessments, we have the engineers and their lawyers, because every team across Microsoft has a team of lawyers who has to think about this. They do that balancing. They do it we hope that they do it, we instruct them to do it in a very thoughtful, technical manner. It's not something we put in our privacy statements, but it is something that we have to share on request with the data protection authorities, and we have done so. And we do it even when the engineers believe they're getting consent, and that's because we're always concerned that the definition of consent is very strict, and it's going to get interpreted in a way that maybe we're not getting the level of consent we think we're getting. So we want to make sure that we've done the analysis, that we're not just relying on consent, we're also thinking about what are the balances between the legitimate interest test in the regulation, balancing our interests versus data protection rights and other rights of individuals. And then I know, Pat, you're going to jump in. Well, I'll let you jump in.
Okay, so if I ask Microsoft for your legitimate interest assessment, would you disclose it to me?
Honestly, we wouldn't provide all of the engineering discussion that we've had internally. We wouldn't.
So how am I supposed to understand the balance? How am I supposed to determine that an appropriate balance has been struck? Because this is about me, it's about the risks to me, my concern. And don't forget that the GDPR talks about interests. That's all the interests of the individual. So how are you understanding what my interests are, and why won't you disclose an LAA in order that I could determine whether or not your reliance on an LAA meets my interests and addresses the risks and concerns that I have?
So I'll say two things in response to that. The first is that your regulator is going to be looking over our shoulder on that, and they have. The second point I'll say is that we do provide not so much a titled Legitimate Interest Objection screen, because we don't think consumers think in terms of legitimate interest. They think in terms of, I don't want Microsoft to do this kind of data processing. And if you exercise that right, or if you feel you don't have that right, then you can come to us and you can ask us, why don't I have that right? And we'll talk through that.
But if these rights are going to be limited by a business, what's the point of the right? If you're saying that actually if you want to exercise this right, we can't provide a service, then is that the appropriate legal basis on which to rely? Shouldn't it be performance of a contract? And as for my regulator, if I'm going to rely on my regulator, I might have to move countries.
Can I bring the regulator into this conversation?
Oh, it was very interesting. I think most of the company have a legitimate interest. But that's not what the GDPR said. It said what the processing necessary is necessary for the purposes of the legitimate interest pursued by the controller, blah, 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 except when such interests are overridden by blah, blah, blah. So everyone focused on the first part of the sentence, like, okay, do I have a legitimate interest? Yes, you're a company, you will find something legitimate. But what the regulator will look at is the other scale. Like legitimate interest will always find. It's what do you do to prevent too much harm to the data subject, and it's difficult to define because it takes a lot of little different things. And from the from the regulator point of view, legitimate interest is an issue in the sense that we're a little bit scared that a lot of companies who don't want to rely their processing on the consent that, I don't want to have their consent to the data subject. But I have it's not really a contract, so, forget about this legal basis too. Well, just rely on the legitimate interest, and I will just have to justify it if the controller asks me so. It's like a reasonable risk to take to base your processing on the legitimate interest, and you will provide more detail if you are asked by the regulator. So it could be long time after your processing is launched. That's why we are worried the overuse of this legal base.
Okay, this is a very, very, complicated and comprehensive discussion, but there are more questions on the floor. And I see you were raising your hand, like the lady in black there. Yeah. Can we pass the microphone to her?
Thanks. I'm Sarah Bird from Mozilla. It's sort of on the same topic. When you talked about the data that Netflix collects on you, as a software engineer, it seems kind of reasonable if you want to make a service better, if you want to understand what users are doing. I understand why you need that. Of course, if you're Spotify and you're using that to sell the exact same kind of data and using it to sell advertising and so on, then all of a sudden I get very nervous. And so the intent is very important, and so if Netflix suddenly got bought by an advertising company, things could, and that data got transferred, and so this whole act of what's happening when and the historical data seems very crucial. So how does this get addressed? Is it being addressed right now? And and that sort of that tension between I think Netflix is legitimate, but Spotify sort of concerns me, and how does that feed into what's happening right now in the grand view of things?
Maybe we can take another question while the panelists think about it. Another question? Anna?
Anna, you had a question.
Okay. Is there any other questions? Okay. There are no questions, so who wants to reply to this question?
I'll just say it actually integrates well with what Rodolphe said, which is the legitimate interest analysis has to look at both what our interest is as any other legitimate interest that's available against the impact on the individual. And so, for instance, if you're doing data collection and processing for the product versus doing it for advertising, those are considerations that need to be taken into account. We also have to take into account how much transparency we're providing at the time when the data subject is providing information, and whether that transparency is still accurate if there were, for instance, as you say, a change in the business model for the company. Those things all have to come into discussion. One thing Pat mentioned a moment ago was that companies say they don't do automated decision-making. I think that most companies may think that they're doing automated decision-making, but not in a way that has legal or other significant effects on individuals. Those questions about whether there are legal or other significant effects are things that need to be taken into account when doing the legitimate interest analysis. And so the examples you gave may come out differently depending on those purposes. I think they would.
Pat? We have
it's
3 minutes.
it's a really good question, and of course, you know, when people want to use personalized services, it requires the processing of a range of data in order to personalize it. But what I see in the privacy policies and the practices is a lack of clarity and distinction between what's necessary for the personalization to me, for example, compared to the advertising and the relationships with partners around personalizing or delivering services and content off of that particular platform. It's a bit of a mire, to be honest.
Okay, so we have 2 minutes to go. So one last comment from the panelists before I conclude. You talk a lot, Pat. Zora?
Yeah, maybe I can come in on the legitimate interest of the users a little bit, because yes, that's something that the companies should also have in mind, because maybe it's great for Netflix if I spend 8 hours binge watching on there, but it's definitely not great for me and for my health. So if they should have my legitimate interests in mind as well, maybe what Netflix or other services could do is, after 3 hours of binge watching non-stop, saying, hey Zora, we've noticed you've been on this series for a long time. Don't you want to take a break? Go out and eat something?
Watch another one?
Instead of saying that, because that would be my interest, right? And then I can make a decision if I want or not, but they don't have that in mind.
Yeah, I mean, this is a very complex discussion, and this research is only the beginning of our adventure, because as TACD, Transatlantic Consumer Dialogue, and I presume as Heinrich-Böll Foundation, we will do more research and we will try to figure out what is best for consumers, because in most of those discussions, the consumer viewpoint is not very well heard. So that's why we conducted this research and we drafted this report to see what are consumer experiences in the EU and in the US and how different they are. And this is, as I said, this is only the beginning, and the report is available at the EDRI desk at the hall. Please get your own copy and read it, change your settings, because we know that most of us use these platforms, digital services. And something I realized after taking part in this research and after reading this report many times, and now we've been discussing in the US the federal privacy law, but the discussion is focusing on compliance. You know, the companies are coming to the discussion from the point that how we can comply with the privacy laws. And this report shows that the compliance is not the solution, because we need this technology to be designed by default privacy settings. Until we start thinking about how we can design the technology, these services, by privacy default setting, we will have lots of discussions like this, we will discuss legitimate interest, we will discuss consumer experiences, but I think it seems that we need to move from compliance to design and discuss how we can build the technology by putting the consumers and the users at the center, not not as the data subjects. So this is the end of our panel. Thanks for coming. This was the coming and joining us. This was the very first panel of the CPDP. And I hope you will enjoy the discussions here. And once again, read the report. Thank you very much.